So let's start off with professional ethics under pressure. Now, solicitors and firms are facing a huge range of pressures at the moment. Competition is very, very fierce, variable depending on the area of law as to whether you're competing just within the profession with other regulated professions or also with the unregulated sector, and the regulatory burden and the burden of new regulation is quite high. I think the SRA are looking to change their handbook potentially from next April. There will be new rules regarding what price information you've got to put on your website from December. They're considering changing the professional indemnity insurance requirements to make them less clear-cut. So there's a heck of a lot to get your head around coming from the SRA, as well as broader regulatory issues like GDPR, anti-money laundering.
Research out there shows that internal structures, billing targets and so forth, commercial pressures can have a significant impact on ethics, and I can go into that in a bit more detail soon. Obviously the external pressures which impact on what your internal structures are going to be like, trying to compete with new entrants to the market, possibly in the future competing with unregulated firms that have solicitors in them and so forth. But yes, competition is greatly increasing. A big concern, I think, is regulation, not just the regulatory burden, but the lack of preparedness for people entering the profession in relation to the kind of regulation that's out there at the minute. So the move to outcomes-focused regulation some years ago, and the proposal to continue to pare back the handbook, I think there's a lot of good things to be said about that, but it needs to be backed up by regulation, by education, I beg your pardon, and I don't think that education is there.
From a litigation perspective, I'm sure Emma will say this as well, with cost budgeting, etc. Now, not necessarily what you need to do or what is reasonable for your client for that case. It's what's proportionate to the value of the claim, and what's proportionate is not necessarily what you really need to be doing, and that's something that we're definitely finding, and I'm sure other people will do too. Proportionality tends to now focus very much on the value of a potential claim in terms of money, whereas that's not necessarily correct for the client or for you. So it's difficult trying to get that balance, and you're criticised very heavily by the court and defendants with claimants for doing what you really should be doing to do a reasonable level of service for that client.
Not that cutting corners would be acceptable anyway, but you make calls within the progress of any kind of litigation or any kind of case. But when you're putting pressure on younger members of staff, or they're being trained to carry out work in that perspective, then that brings into account the quality of the younger members of the profession going forward as well. And I think that as a profession we've commoditised ourselves. The government are looking to squeeze costs continually. They are creating an environment where Joe Public is advised to shop around to get good quotes, to try and do things on fixed fees, and it's not always in their best interest in terms of delivering the result at the end of the day.
It seems extraordinary to be in a situation where we are competing now, it seems, directly with wholly unregulated Mackenzie friends who are charging fees. This seems to be, in professional regulatory terms, turning the clock back to table profession, medicine, 1700s, dentistry, the late 1800s, and I'm not quite sure where you gauge it in terms of lawyers.
Universities don't teach ethics. There's very few people who actually look at legal ethics in the UK. It's just not a subject that's been on the agenda. And this is something that universities are going to have to look at with the SQE coming in, although many of the research intensive universities will not be teaching SQE degrees. But it is a big problem, and I also did the I did Law Society Finance, but I did teach on the LPC actually for a number of years, and the questions that are given, and I do research ethics now and outcomes focused regulation, and the questions that you're given are just very black and white questions. They're not the difficult ones. There's nothing that is preparing you for the kinds of really open-ended exercise of discretion that people are having to deal with now. I think from the point of view of ethics, what you want in the firm is a culture where people can own up to their mistakes and not be punished or victimised for it. And this actually goes to obviously being able to deal with the mistakes sooner rather than later in the client's interest, but it also goes to the culture of the firm. And the culture of the firm, if people are treated with respect, if there is a culture which is good HR, where people are treated properly. This actually promotes ethics in the firm, because there's a lot of research out there, and that's why I'm here to talk to you about the research. There's a lot of research out there that says that if people are treated properly in firms, if the employment processes are right, if they're listened to, treated with respect, they're far more likely to buy into the firm's culture of compliance. Whereas if you have peeved employees, they're not going to do it. So HR issues are ethics issues.
Yeah.
I had an interesting one. The first GDPR complaint that I've had to deal with as MD of my law firm, which was something silly and ridiculous and thoughtless. But I can see exactly how it happened, which was that a solicitor was reading a file on the train, and a member of the public came and sat next to the solicitor and read all sorts of information in this file, and this member of the public then emailed me as MD of the law firm, and so there were several issues there, but also I had to go to the ICO to get advice from the ICO as to how to deal with it. And in actual fact, I felt that the outcome of the report that I made to the ICO was far less onerous than what I felt ethically had to happen in terms of the client and the way we as a firm addressed it, because as far as the ICO were concerned, they felt that it wasn't something that could happen due to the nature of what had been read, the data that had been breached, that it wouldn't have a material impact on the individual, etc. And as far as they were concerned, that's the end of it. But there were steps that we had to take internally, and then the big question from my colleagues was, well, do we have to tell the client? And my approach to it was, absolutely we have to tell the client. That was a real ethics question that I felt from a new subject area that we had to address, and one of interest. And again, a reminder of how easily these things happen.
Yeah.
Because ultimately, I just have a member of staff who's trying to do their job and use their time well, and and they've not thought it through. It wasn't something done on purpose.
No genuine mistake.
It was it was ill considered, wasn't it? Because if they had have thought about it, they wouldn't have opened that file on the train. But they're trying to do the best, and they could have used the argument, well, I'm subject to time pressures and billable hours, and I haven't got my time recording done, and I can charge for the work that I'm doing on this file while I'm sat on the train. You can see it all unravelling, can't you? Then all the things that we've just talked about in that one particular instance,